Judgment in the appeal, Nuclear Decommissioning Authority and EnergySolutions.
Lord Mance will explain the judgment of the court.
This appeal arises from a decision by the defendant, Nuclear Decommissioning Authority, a non-departmental public body, which I can call the authority, to award a decommissioning contract for some 12 sites to a consortium known as CFP, rather than to another consortium, Reactor Site Solutions, of which the claimant, ATK Energy EU Limited, was a member. The proceedings have now settled, but the parties have asked that this judgment be issued nonetheless to clarify the legal position. The judge held that in awarding the contract to CFP instead of RSS, Reactor Site Solutions, the authority made many manifest errors, but for which it should have awarded the contract to RSS. ATK's claim is consequently for breach by the authority of its obligations under the Public Procurement Regulations 2006, which give effect in the United Kingdom to the Public Procurement Directive of the European Union, the PP Directive. The PP Directive is supplemented by another directive, as amended, the Remedies Directive, which requires effective remedies in cases like the present, including compensation and or the setting aside of awards. The 2006 regulations were amended to give effect also to the Remedies Directive. Regulation 47G of the 2006 regulations, as amended, therefore requires a contracting authority, on becoming aware of the issue of a claim form relating to a procurement award decision, to refrain from entering into the contract with the successful tenderer, if it hasn't already been entered into, until either court order or disposal of the proceedings. 3 issues were argued before the Supreme Court. Firstly, whether the Remedies Directive, as a matter of EU law, only requires a damages award to be made when any breach of the PP Directive is, quote, sufficiently serious. The Court of Appeal held in answer to this, yes. Second, whether even if that is the case under EU law, the domestic law provisions of the 2006 regulations confer a power to award damages in respect of any loss or damage suffered by an economic operator, such as ATK, in the case of any breach, even one which is not sufficiently serious in EU law terms. Again, the Court of Appeal held yes. So domestic law went further than EU law required. Thirdly, whether and if so when ATK might be refused a damages award under the 2006 regulations, since, after being notified that the contract had been awarded to CFP, it delayed making any claim against the authority until after the authority had actually entered into the contract with CFP. Under the regulations, ATK could, by issuing a claim immediately, have prevented that contract being entered into at all, and so avoided the loss which it now claims, or claimed. The Court of Appeal held no in answer to this. A damages award couldn't be refused on that ground. The Supreme Court reaches the same conclusion as the Court of Appeal on Issue 1, differs from the Court of Appeal and allows the authority's appeal on Issue 2, but dismisses the authority's appeal on Issue 3. Lord Mance gives the judgment with which all the other members of the Court agree. As to Issue 1, the decision of the European Court of Justice in Spiker, a 1998 case, is clear authority that the liability of a contracting authority under the Remedies Directive for breach of the PP Directive is assimilated to that of a state or other public body for which the state is responsible. Such liability is therefore only required to exist when the minimum Francovich conditions are made, and that includes a requirement that the breach must be sufficiently serious. As to Issue 2, the UK legislator did not, by the 2006 regulations, go further than EU requires by conferring a power to award damages in respect of loss or damage suffered in the case of any breach, as opposed to only a sufficiently serious breach of the regulations. The domestic legislator's intention was not to gold plate the European directives. It was to do the minimum necessary to implement them. The Court of Appeal erred in assimilating a claim for damages under the 2006 regulations with a private law claim for breach of a domestically based statutory duty, and in assuming that this automatically freed the claim from any EU law conditions which would otherwise apply. That conclusion is also consistent with the use of the word may in the relevant regulations. As to issue 3, the Remedies Directive provided for a minimum standstill period from the date of any contract award within which period no contract could actually validly be entered into, and the 2006 regulations provided domestically for exactly the same period. However, the 2006 regulations went further in a different respect by allowing a 30-day period for claims for breach of the regulations, which was longer than the minimum 10-day period for claims required under the Remedies Directive under EU law. The authority, in fact, granted a 14-day standstill period, after which it then proceeded to enter into the contract. ATK waited until this had occurred before issuing the present claim within the permitted 30-day time limit. ATK's only claim can therefore be for damages, but by failing to claim in time to stop the contract being entered into, it cannot be said to have failed to mitigate or avoid its loss in a way depriving it of any claim to damages. The scheme gives both parties choices as to how to proceed and how to protect themselves. The authority could itself have delayed entry into the contract until after the 30-day period within which ATK had to commence any proceedings. ATK may not have issued its claim form at a time when this would have put an automatic stop on entry into the contract, because it appreciated that this would lead to the authorities seeking to lift the stop. And under the regulations, that would in turn very likely have led ATK having to put up security for any loss the authority would suffer through the continuation of the stop. An economic operator like ATK cannot be said to have acted unreasonably in refraining in its own interests from a course exposing it to the risks associated with the possibility of its challenge to a contract award decision failing.